Hello and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer and I'm the Extension Legal Specialist here in the Department of Agricultural and Resource Economics at the University of Maryland. And today we do not have a guest on the podcast. It's going to be me talking a little bit about what's going on with latest in dicamba and some of the litigation that's been going on. Hopefully over the next couple of weeks we'll bring on some more guests to talk about various issues, to keep you up to date on how things have changed potentially over the past few months or what we should be looking forward to into the future as people start making decisions about next year and, other basic management decisions they might have to be making. But we have dicamba. It's been back in the news lately in several areas. EPA recently moved, as you have seen probably within the past 2 months, to cancel the registrations for 3 dicamba products based on a ruling in the Ninth Circuit. The growers have until the end of last month, July 2020, to use existing stocks. Using them after August 1st would no longer be approved under the label, and that's not currently allowed. In other news, Bayer, the parent company of Monsanto, recently announced a settlement of around $400 million for class action lawsuits filed against possible dicamba drift caused by the company's XtendiMax product. Details of that settlement are not known at this time, so let's kind of get a sense of what all this means for growers. So what are the dicamba drift lawsuits about? Let's start with those first, because those are sort of the more pressing and ongoing issue, and we can talk about the EPA part here at the very end. Producers experiencing dicamba drift damage brought the current in-ray dicamba herbicides litigation against the manufacturers of the dicamba-based herbicides XtendiMax and Eugenia. With federal claims, the plaintiffs argue that Monsanto and BASF Corp. Violated Section 1125A of the Lanham Act in marketing both XtendiMax and Eugenia-based herbicides. The plaintiffs also allege state claims focus on nuisance in product design, failure to warn of negligence in the design, failure to warn of the dangers, and just poor training of sales associates for the 2 dicamba-based herbicides. Only one of those federal lawsuits has gone to trial on similar. So we've only had really one federal lawsuit go to trial on similar claims that we're seeing in the in-ray dicamba herbicides litigation. A federal jury in Bader Farms versus Monsanto awarded a Missouri peach grower close to $265 million in damages, 15 in actual damages, and then $250 million in punitive damages. This is still under appeal. So what do you need to know about this settlement? Well, we don't know the exact terms at this time. The plaintiffs and defendants have agreed in principle to settle claims on yield loss due to dicamba damage from 2015 to 2020. About $300 million of the settlement will cover specific losses to soybean growers during that period. Another $100 million will go to non-soybean damage, and included in that will be some attorneys' fees for the plaintiffs' attorneys in there as well. So who all will be eligible? That is still not known at this point. We don't know how broad eligibility will be. We don't know how narrow it will be. We do not know if this will be nationwide or limited to the class action lawsuits. As mentioned above, we currently know basically the years that will be associated with yield damage. We don't know who all will be included in that. We're going to have to wait for details from the final settlement agreement to understand who's eligible. How do you apply? Well, this is another good question that people are going to start asking here as this gets out more in the news. We'll know more of that when the final settlement is announced. We'll get a sense of the timeline of eligibility. We'll get a timeline sense of, when we can expect growers to start signing up, and what they're going to have to turn in to be able to apply. Since the settlement includes this crop year, we can expect that sign up would not start till after this year. Because the settlement's based on yield damage, we're going to assume that you're going to have to submit some sort of crop insurance documentation, some sort of calibrated yield monitoring data to verify that you had loss due to dicamba drift damage. But again, we don't know at this time what any of this settlement means. And that's one thing I need to kind of reiterate on this, is we're really not going to know what any the mechanisms are, any of the details within the settlement until we see the settlement and it's approved by the court. And that's going to happen much later this year, or maybe early next year, just depending on the timeline the court is taking on this. So that's all we really know on the settlement right now. So how does this relate to the ongoing lawsuit in the Ninth Circuit Court of Appeals? Well, that settlement, we had the settlement with the class action, and then we have this ongoing lawsuit in the Ninth Circuit that are related only in the sense that sort of, there's this dicamba-based herbicide products, and that's about it. They're based around these same products, but they're really based around different claims. As mentioned earlier, the class action settlement is based around federal claims that the defendants violated the Lanham Act and state law-based tort claims. The claims in the Ninth Circuit are related to EPA's approval of the 2008 registration for BASF, Bayer, and Corteva dicamba-based herbicide products. Based on the court's vacatur ruling of that registration, EPA has moved to cancel those 3 dicamba-based herbicides registrations. Under the Federal Insecticide, Fungicide, Rodenticide Act, or FIFRA, EPA only has the authority to either cancel or suspend pesticide registrations. With a suspension or cancellation, EPA can set the conditions on which canceled or suspended pesticides can be sold or distributed or used till a certain date. If EPA didn't go about doing this, the court could vacatur the registration, but the products would still be on the market and EPA would not set a way to get them off the market. So looking forward, what do we know? The 2018 registrations for those 3 products would have expired later this year. EPA will now have to consider the Ninth Circuit ruling in this re-registration process. That re-registration process, and is now going to take into account some of the details that the Ninth Circuit brought up to make sure that EPA follows the proper process required within FIFRA to do it. So it's going to be a little bit more of a stricter process for the 3 companies in this. We're going to have to pay attention to see what happens with these product registrations or re-registrations for the 2021 growing season. At this point, based on the Ninth Circuit, we wouldn't have any of these 3 products. There still would be the 4th product on the market. It was not taken off because of this, but we would have to determine, what's going on to determine if these other 3 products could come on the market. So thank you again for listening. If you have any questions, please email me at lgoering@umd.edu, or you can tweet me at aglawpaul. If you have any thoughts on future episodes, please let me know. And thank you again for listening, and enjoy the rest of your day.